to transfer the assets for defense, reconstruction, and compensation of Ukraine before it's too late. This is absolutely necessary right now, not only for Ukraine, not only for Europe, but for the whole international law-based order.
Mykola. Welcome to the Lawyering Peace interview series, where we explore the art of diplomacy and the legal frameworks that underpin peace processes. You are listening to our special series focused on peace negotiations and peace building in Ukraine. Join us as we hear from prominent figures who've played pivotal roles as lawyers, negotiators, and diplomats for the quest for peace in Ukraine. I'm your host, Dr. Paul Williams, the founder and president of the Public International Law and Policy Group, and the Rebecca Grazier Professor of Law and International Relations at American University. Now, in recent months, there have been halting steps towards negotiations to end Russia's war of aggression against Ukraine. And with our guests, we explore some of the key issues and challenges that arise or will arise during negotiations and possible options for tackling these head on. We interview Ukrainian and international experts on issues ranging from territorial integrity and post-conflict elections to negotiating security guarantees, justice, and reparations. Today, I am deeply honored to welcome Mykola Yurlov. Mykola, welcome to the program.
Thank you, Dr. Williams. It's always a pleasure and a great honor for me to interact with PILPG, whether through our joint work in the academia or now through my government engagement. And of course, it's a great honor for me to be a guest at the podcast and speak directly to your audience to explain Ukraine's position on complicated issues of international law and policy.
Well, Mykola, we're so excited to have you on our program today to walk through some of these issues. Let me give our audience a little bit of a background. Many of them are familiar with your work, but for those of who are not, Mykola is a Ukrainian diplomat and a legal expert specializing in international humanitarian and international criminal law. He recently served as the deputy director of the Department of International Law and Cooperation at the Ministry of Justice for Ukraine, where he led the international disputes and damage compensation units. Now, in this role, he oversaw Ukraine's participation in investor state arbitrations, commercial arbitrations, and cross-border disputes. He also contributed to the development of an international compensation mechanism and the proposal for a special tribunal for the crime of aggression, which is making substantial progress at the moment. If that wasn't enough, he also participated in negotiations on bilateral security agreements and worked to bring about Ukraine's ratification of the Rome Statute and participated in the drafting of its implementing legislation. Now, previously, Mykola worked as a senior legal counsel at Truth Hounds, a leading Ukrainian human rights NGO, which is where I first got to know Mykola, where he supported war crimes investigations and advised legal professionals on accountability for international crimes. And if that's not enough, he has also taught international law at Yaroslav Mudry National Law University, where he co-led their efforts in international law and the moot court community. Now, today we're going to draw on Mykola's extensive expertise to discuss Ukraine's compensation mechanism, the register of damage, and the possibility of transferring Russian sovereign assets to fund that compensation mechanism. So let's dive right in. Mykola, the first question I always like to ask my guests is one to get us to know a little bit more about your journey into international law and the work that you're doing. You bring with you a wealth of experience from Truth Hounds, where you were documenting Russian war crimes in Ukraine, to academia, now the public sector. What inspired you initially to become involved in international law, and then also to make the transition from civil society to public service? spend some time and walk us through your journey.
Thank you. Thank you, Paul. Indeed, the international law has been a very active realm of knowledge ever since I first encountered the concept of international relations as a small kid back in school. I come from Sevastopol, Crimea, which has been at the forefront of many world wars, and only world wars, but local wars as well. And it is precisely there in Sevastopol where the Russian war against Ukraine started 11 years ago. So, though my service began well before the war began, I initially was drawn into the world of international law directly through the Jessup moot court competition and concept of debating the brightest legal law students out there and becoming one of the best, like Kiev Mykola Academy did this year, qualifying to the finals, becoming the first Ukrainian teams. I would like to say hi to them, guys. You're amazing. And especially to the first applicant for that amazing rebuttal, still the best rebuttal I've ever seen in Jessup. Yes. But it was then when international law began to interest me, and I started under the guidance of my scientific advisor, Professor Boromensky. I started digging deep, and my first topic for a PhD, which I had to scrap, was the legal basis for the dislocation of Russian Black Sea fleets on the territory of Ukraine. And just as I entered the PhD program, the war began. And so I had to drop that topic, and for a while, I ultimately did not complete my PhD studies. I transitioned to private practice. I practiced investor-state dispute settlement in different law firms. And when the full-scale invasion began, of course, initially there was this understanding that, well, international law is dead, it's useless. I still have that Facebook post from early 2022, which have been heavily criticized from my colleagues. But ultimately, the value of international law comes only from its enforcement. And if we just blankly state, okay, it's not working, let's forget about it, then it's never going to be able to be resurrected, if I may. So when the full-scale invasion began, I tried to go fight a couple of times. Actually, a couple of dozen times. I applied for combat roles, but for various reasons, I was refused. So I started working with Geneva Call. I was teaching IHL to combatants. We were focusing on territorial defense forces and legions like International Legion, Georgian Legion. And after a while, I was invited by Dmitro Koval to join Truth Hounds, where I worked where we've met you, and where I worked on the Zaporizhzhia nuclear power plant torture report, hate crimes in international armed conflicts, investigation guidance, as well as other reports. And in the beginning of last year, in the early 2024, I was invited to join the Ministry of Justice International Law Department to reinforce its functions on the damage compensation and dispute resolution for arbitration. So where I have worked with my colleagues, Zahar Tropin, who was the director of that department, as well as many other colleagues in that really great unit. I can say that I think Zahar would agree with me as well. We were quite proud of what we have achieved throughout that year. A lot of good progress done on both the compensation mechanism, on the Rome Statute ratification, and where we helped our colleagues from the Ministry of Foreign Affairs on the Special Tribunal for the Crime of Aggression. And now I'm starting in my new role at the Ministry of Foreign Affairs. Details will follow, but let's stop at this. Let's stop here.
Mykola, that is quite the journey. And I'm so glad you mentioned Jessup Moot Court. It just happened this last week here in Washington, D.C. And it's so amazing to see, talented young lawyers from all over the globe come and compete, yes, but build those global relationships that they'll carry through the next 5 decades. And yes, the Ukrainian team was very impressive, as well as the American University team this last round of negotiations. Let's pivot now a little bit into helping myself and our audience understand where the current state of play is with repurposing frozen Russian assets. There's hundreds of billions with a B dollars of Russian frozen assets in Europe, in the United States. There's a talk about, hey, right, let's repurpose these for compensation for Ukrainians who've suffered damages as a result of Russia's war of aggression. Just walk us through where that conversation currently stands.
Sure. That's the issue of Russian frozen assets has been at the forefront of the discussion about compensation. And let me take a step back and talk about the initial conception of the mechanism. So when the war escalated into the full scale invasion, and it was evident that there is a necessity to react. My colleagues, Irina Mudra, who's now the deputy head of the office of the president and was at that time the deputy minister of justice, and Markian Kluchkovsky, who is now the executive director of the Register of Damages, together with backed by international law academia, have devised this plan for an international compensation mechanism, which comprises three elements. The first one, which is the Register of Damage, which has now been launched. It's completed its first year of functioning. It's going to have a total of 45 categories of damages. About a third of each are going to be private persons, state, and legal entities. As of now, the first 9 categories have been launched. So the question is now only in technical implementation because it requires this digital support to ensure all the data security and other issues. So the rollout of the categories takes some time. But the register is already functioning and has accepted its first 20,000 or so claims, with much, much more expected. We're expecting millions of claims when it's fully rolled out. The next element, which is being negotiated right now, is the claims commission, the purpose of which is to evaluate the claims submitted to the Register of Damage. And we have had, with the kind support of the Kingdom of the Netherlands, who was the host, the 4 preparatory meetings to discuss the draft treaty, where we walked with about 54 delegations in each of these meetings, 54, 55, the concept for the claims commission, and then we discussed particular legal formalities of its establishment. And now we've begun the formal negotiations, the first round of which have been completed last month, also in The Hague. And if all goes well, we expect to complete the negotiations of the Claims Commission by the end of this year. And this is really our goal, because I will not repeat the old adage of justice delayed is justice denied. We all have a clear understanding that time is of the essence in this case. Now, the final element, which has not been discussed through the legal teams within the compensation mechanism yet, is the fund of the international compensation mechanism. And the reason for that, I decided to trifurcate the proceedings, is because we understood at the very beginning that there are very significant differences in understanding of the way that that fund could be filled. So we decided to proceed with the other elements and then go to the formal discussions about the fund when we finalize the work in the Claims Commission. But at the same time, of course, the biggest question was, can the Russian assets be used? And though we did not formally discuss it within the international compensation mechanisms discussions, negotiation, we have always talked directly, Ukraine has talked to all of our partners, and specifically to those states where those assets are located, about the possibility of using countermeasures as provided by Articles on State Responsibility for International Wrongful Acts as a way to transfer those assets to the international compensation mechanism when it is created. And here, of course, the basis of a legal argument is the memo developed by the leading international law professors. If I may name them all, not to be name bragging, but I am. So the letter, which is the letter that follows the memorandum, the legal memo explaining the use of countermeasures, was signed by Professor Olivier Courtin, Professor Shotaro Hamamoto, Professor Pierre Klein, Harold Honjuko, Paul Reichler, Professor Hélène Ruiz-Fabry, Professor Philip Sands, Professor Emeritus Nico Schrivier, I'm sorry if I mispronounced, Professor Christian Tams, and Philip Zelikov, as well as Dapo Kanda. And this reflects our understanding as well that international law of countermeasures allows the states, either through the erga omnes or through the specially affected concept, to transfer the assets of the Russian central bank to a fund from which these assets will be used to compensate for the damage caused by Russian aggression against Ukraine. The crux of that argument lies in that the Russian violation of international law, which is aimed at destroying the whole international order based on the rules of international law, is so egregious that it allows, as a countermeasure which is reversible and temporary, those states to transfer these assets to a fund to compensate the damage caused by that violation. And the question of reversibility is achieved through a set-off mechanism. And if I just may briefly explain that, I know we don't have much time, but in a nutshell, the amount of damages we have, according to the latest reports by World Bank and United Nations, EU and Ukraine, the RDNA4, is estimated at slightly below 600 billion only for the 3 years of the full-scale invasion. That the cutoff date for that report is 31st December 2024. Taking into account the damages starting from 2014, we have a number north of $1 trillion US dollars, according to modest estimates. So the full amount of damage for all 11 years of the war has not even been fully calculated, but we have very early estimates that it is north of 1 trillion. So the transfer of those 300 billion US located in different jurisdictions to the compensation mechanism with liabilities. And that's a key point because that's the question that has often been raised, that the assets are transferred together with liabilities to a special fund, which is then addressing and paying out these compensations. It could be set up within the international compensation mechanism or separately and use a part of its proceeds to pay out the compensation directly. These assets, the reversibility is achieved exactly by the fact that when the Russian Federation will come to that fund and request to pay the 300 billion back, and that's why we're not using the term confiscation when we're saying transfer, this duty to pay 300 billion back will be set off against Russian duty under international law to pay for the damage it has caused. And that duty has been recognized by the United Nations General Assembly, resolution supported by 94 states. So I'm happy to answer more detailed questions, but that's our legal theory.
No, Mykola, that really helps to explain the legal theory behind setting up a mechanism to transfer these assets. What are some of the legal challenges that you faced in setting up the compensation fund and in mapping out a path to transfer these assets? And how have you overcome these legal challenges?
Well, first of all, indeed, the concept of countermeasures is a rather uncommon, so to say, for many practitioners who are classic international law advisors in the ministries of foreign affairs. And of course, there is some sort of a reluctance to go after the sovereign assets because we don't have any precedents for this being directly done by others, by states which have not been the victims of aggression themselves. Our response to that is, of course, that the situation that we have, the genocidal aggression of the Russian Federation, which is absolutely unique for given its gravity and given its attempt to annex the Ukrainian territories and destroy Ukrainian people as a nation. And the genocidal intent is extensively proven by both their statements and their actions. There's a great article on Oxford by my former colleague from 2000, Dmytro Koval. She co-wrote with Denis Azarov, Gayaneno Rydzynian, and Vladimir Venherai, as well as there are two excellent reports by Raoul Wallenberg Center and New Lines Institute, which I do recommend everyone to have a read if there is concept. But we are very confident that what we have here is an outright case of a genocidal aggression and a crime of aggression conjoined with a crime of genocide. And the gravity of these violations is so severe, and the outcome and the consequences, not only for Ukraine, but for the whole world, the threat to the whole international law-based system is so severe that if the states do not act now, there is, of course, here's where I'm adding the policy argument to my legal argument. But if the states do not act now, then the whole concept of international law may become absolutely meaningless. And the fact that we have very strong legal theory, which has not been disproven. Of course, there are scholars who disagree, but as you know, when there are two lawyers, there are three legal opinions. So it is absolutely natural for academia to debate and disagree. But so far, we have not received a single meaningful rebuttal to this legal theory of countermeasures, which covers all bases on reversibility, of course, proportionality as well. And the question is now not in the realm of law. The question is now solely within the political realm. There's also an economic argument to that side about the risks of stability to European currency. But again, that argument has been as well disproven by a very fresh report by world's leading international economists, which has been published by Kiev School of Economics. And it basically comes to the following conclusions: that the implicit precedent for those fears to the stability of European currency that we have often heard throughout this 3 years has already happened when the states have frozen those assets and declared that those assets will remain frozen until Russia pays. So from the point of view of international financial markets, that means that those assets have already been de facto transferred and they're not reversible. So the fear that we often hear that if those assets are transferred, then the European currency will suffer is just not substantiated by evidence. And there is the European Central Bank. Again, we're getting into economic territory, but I'm just retelling the conclusions of economists. European Central Bank has more than enough financial instruments and regulatory power to address any potential risks to European currency. So if anyone has concerns, I encourage you to read the report published by KSE. It addresses them all. Now, the key question is only the political will of the members of the states which are holding these assets to use them for the reconstruction, compensation, and now, given the critical need, also the defense of both Ukraine and Europe.
Well, Mykola, let's pick up a little bit on political will, because you and I are lawyers, and two lawyers, three legal opinions, of course, and we're always optimistic and hopeful that the legal framework will be applied and utilized by countries. And as we're both legal advisors or have been legal advisors to our governments, you always bump into this question of political will. Do the democratically elected leaders have the will to take this action? What is your assessment of the political will at the moment in Europe to repurpose, to transfer these assets for compensation? And I would just note that I've been intensely impressed with the degree to which Europe has maintained its political will and focus on pushing back against Russia's war of aggression in Ukraine. But political will can be fickle. So walk us through a little bit where that political will stands and what you project for the future.
Well, This is hardly an academic debate here because you can't measure political will in kilograms or gallons. But what we see are the signals that we evaluate. And the signals so far are very promising. Not only the Council of Europe's Parliamentary Assembly has once again called and universally supported the resolution to transfer those assets, we've now, for the first time, have the vote of the European Parliament calling for precisely that. To even further demonstrate the change of thinking in at least the European capitals, we see that the French Assemblée Nationale has also passed a resolution calling for the transfer of assets, which marks a very significant departure from France's previous position, which was very much against the transfer of assets. What we have now is the understanding of European partners of what we have been saying from the first days of this war, and what we have been saying even more since the first days of the full-scale aggression, that the war is not about Ukraine. The war is not about my home city of Sevastopol, or Crimea, or Luhansk, Donetsk, or Zaporizhia, or Kherson. The war is about the fundamental principle that govern international relations. And now, if Ukraine falls, or even if we're stuck in this gruesome semi-ceasefire, semi-whatever frozen conflict, the Russian Federation will have a very clear possibility to continue its conquests. And they have been very clear that their official ideology is Russian borders do not end anywhere. This is a political regime that openly not only challenges, it attacks and attempts to destroy the borders that have been agreed as the fundamental condition for lasting peace in Europe after Second World War, and the principles enshrined in the United Nations Charter. So there is now a very clear incentive and also understanding that if the situation changes with respect to the sanctions that are freezing those assets at the moment, the assets may be returned to Russia, and they will then be used to fund Russia's new conquests against Baltic states, against Finland, against Poland, against perhaps Central Asian states or Moldova. So there is now a very clear security element to understanding that these assets must be used for defense and reconstruction of Ukraine, and ultimately for the benefit of the whole continent, and hopefully for the benefit of the whole international law-based order.
Mykola, do you see this as creating a precedent for future conflicts? Because there are so many assets accessible in the global marketplace, so to speak. And this is a fairly innovative and well thought out and legally grounded approach to compensation for damages caused by Russia's war of aggression. Are you thinking that we're going to see more of this in the future? You know, thinking back to the Yugoslav conflict, how difficult it was to secure assets for reparations, reconstruction, compensation in Bosnia, Kosovo, Croatia, et cetera. Looking at, Eritrea, Ethiopia, places like that. Is this a one-off with Ukraine, or have you all invented something that we're going to see quite a bit of in the fabric of post-conflict?
Well, the answer to that question is twofold, and it's yes and no. So the point in which it will not, and we hope it will not be a precedent, is that if we now muster a strong response and make sure that the aggressor states pay the price for their crimes, we hope that this will be a very strong signal to dictators around the world that their crimes, their aggressions will not go unpunished. So, in a certain way, our situation is of such a grave nature that we have the almost universal condemnation of the aggression at the United Nations level, and a very strong support for the compensation in the furtherance of remedy resolution of the United Nations General Assembly. What we would not like to see, of course, is that it if it doesn't work through, then there will be no consequences for further conquests by whatever state, not only Russian Federation. At the same time, what we can see is that for the other contexts and other conflicts that have happened in the past, there may be some sort of a precedential nature. And we're especially looking, for example, into the South American contexts where they have very good experience, and we're trying to learn from them as well in their own justice and reparation mechanisms. And that's why we're focusing a lot of our work on inviting the new member states from non-European countries. It's really important to have South America with us and Central America, Latin America. It's very important to have African states with us who have also the nations of which have suffered a lot from various atrocities and international crimes. It's absolutely important for us to have the Middle Eastern and Asian states who also have a lot to share. And we hope that we will be able to create something that will be used for compensation purposes in other contexts as well. So that's why I'm really trying, and not only me, all of my team and all of Ukraine's position that it is not a regional matter. Even please do not be confused by the Council of Europe framing of the Register of Damage. Council of Europe is a great organization. Technically, it is regional, but first and foremost, it's values-based organizations about human rights. And that's why we chose it as the vehicle for the creation of the Register of Damage, and hopefully, if the negotiating states decide, also for the Claims Commission. But by no means, it's not limited to Europe. And we're happy to see member states negotiating from Gulag, from other parts of the world, from Oceania, from North America as well. So it's really not about a European local context. It's about the universal rules of international law and the way that we create mechanisms to enforce them. Because no rule is good by itself. It needs an enforcer. It needs someone, a community of states, make it into concrete consequences for those who violate it. And that's why we're really grateful for the support that we are receiving, unlike the support that we have not received in the first 8 years of the war. And now everything has changed, and everybody understands that something that we have been shouting about since 2014. If aggressors go unpunished, they go further. The lessons of Munich have not been learned well by anyone, unfortunately. And as once again the old adage goes, the history does not repeat itself. It rhymes with itself. And unfortunately, we have a very clear, although ominous rhyme happening. But we still have a chance to stop this from escalating even further, from it going beyond Ukraine and beyond the other contexts where the wars of aggression or international crime are happening. And it is exactly the precedent of Ukraine that could serve as a tremendous step forward for international justice.
Well, Mykola, let me pick up on that point. You've been very generous with your time. And so I just have two more questions for you. The penultimate question is this. Can you situate the Register of Damages and the compensation mechanism in the constellation of lawfare, legal activities that Ukraine is taking to push back against Russia's war of aggression? And as you say, to firmly reaffirm the precedent that aggressive wars are illegal. Ukraine, and you in particular, have been very busy in many instances, the Tribunal of Aggression, the International Criminal Court. Walk our listeners through just the collage of legal undertakings that Ukraine is doing to complement what it's doing on the battlefield.
Indeed, the legal realm of our quest for creating comprehensive, just, and lasting peace is provided in detail in point 7 of Ukraine's peace formula, which has 5 key pillars. The first one is the prosecution of international crimes committed on the territory of Ukraine, which is first and foremost spearheaded by our investigators, prosecutors, as well as, of course, judges and trial attorneys who are working to ensure that the fair trial is made. And there's tremendous effort from civil society here. And I have personally had the honor to contribute to the documenting efforts, which are all then processed together. We do have quite a unique situation when civil society and human rights organizations are working together with law enforcement, not against law enforcement as it usually has been, because they have always been the watchdogs. And now they have joint efforts to restore justice to victims. So the first pillar is the prosecution of national crimes on the national level. The second pillar is the prosecution of these international cooperation in prosecuting these crimes. And for this, we have the joint investigative teams. We have the International Center for the Prosecution of the Crime of Aggression, which is another important element. Well, it is more addressed in the following pillar. And this is where we engage the best legal and international criminal experts, which are working through various organizations or directly with our law enforcement to create better investigative mechanisms to implement the best standards of prosecution for international crimes. So this is the next element which is related to it. Now, the third one is, of course, the International Criminal Court, where we are very happy that we have been able to convince our internal stakeholders to ratify the Rome statutes. And I will not go into details about how that story went. There is a very detailed podcast on Ukrainian Bar Association about this. And I'm happy to send the link to it as well to address the reasons why we had no option but to make the Article 124 declaration to make this happen. This is another very long talk, but it's been already discussed a lot. The main thing that Ukraine has joined the International Criminal Court now, and we hope that we will able to contribute to the International Criminal Court operation, not only in Ukrainian context, but in other contexts as well. International Criminal Court is not about just Ukraine. It's not about any particular other politically divisive situations. It is about the protection of common interests of mankind as a whole. And that's why we absolutely need the ICC. It is critically important. This is a unique achievement of humanity, and we must safeguard it at all costs. So Ukraine's full support of the ICC is absolutely unwavering. We're trying to do everything in our power to make sure that it is functioning, it is continues its work in Ukraine and in other contexts. The fourth element is the Special Tribunal for the Crime of Aggression. Indeed, I think it would be best to refer to my colleague, Ambassador Korinevich, on this one. But in a nutshell, you could have seen that the core group has completed its legal work at the expert level, and we're awaiting the political decision to move forward, which we expect to happen very soon. We are very optimistic about it because the Special Tribunal for the Crime of Aggression is absolutely needed to close this accountability gap. Ukraine is, of course, mindful of the Kampala review process, and we have ratified the Kampala amendments. We hope to be participating in the review conference as well. But a special tribunal is a one-of-a-kind solution for a one-of-a-kind problem. And until we have the jurisdictional limitations in Kampala, we must ensure there is no imputability for the crime of aggression against Ukraine, whether it be committed by Russian or any other nationals. So the special tribunal is one of our key priorities, and we hope to expect news about it very soon. The final pillar is the international compensation mechanism, about which we have talked in great detail. There is likely to be some sort of a connection between them, especially when we are taking these pillars as a common web of accountability, which we are building together with our partners. And especially, we have to, of course, thank the Kingdom of the Netherlands for their pivotal role in organizing these efforts, as well as all of those other member nations that are supporting us in this process.
Now, thanks, Mykola, for giving us that overview of the constellation. As I mentioned, it's really impressive the way in which Ukraine is utilizing the norms, rules, processes of international law to complement its kinetic fight against Russia's war of aggression. Well, I just have one last question for you, Mykola, and that is, what is the one key takeaway that you want our listeners to understand and to remember as they think about repurposing Russian assets to compensate the Ukrainians who've suffered harm and suffered damage as a consequence of Russia's war of aggression?
Think I would compare the whole debate about the risks of repurposing or transferring the assets to the debate between anti-vaxxers and those who support the evidence medicine. So the logic of an anti-vaxxer is that there is a risk that a vaccination procedure may lead to complications. And all pharmaceutical manufacturers to admit that risk, usually it's like to 10 million, or for severe consequence, or 1 to 100,000 for milder symptoms. Now, the risk of not taking a vaccination against, for example, something like a very dangerous disease, which could, like polio, for example, right? Child mortality, it's very high. But the act of going and getting your child vaccinating is something that causes this distortion in perception of vaccination. And it leads to the wrong conclusion that not taking an action is safer than taking a lower risk, which it is in practice. I know that argument may not fall to all of our audiences, but from the point of view of behavioral psychology, it is exactly the sphere of action that distorts the views of many. In times like we have in 2025, the fear of action can be lethal. And not only for Ukrainians, because we are paying our price for freedom. And that price is huge. The price when we fall, if we fall, we hope that we will not, will be paid by you guys. So you can still act now and make that decision to transfer the assets for defense, reconstruction, and compensation of Ukraine before it's too late. But the chance is still there, although the window is closing. We have all the legal, the economic, the political arguments. You can share my contacts with anyone who's inquiring. I'll be happy to provide them in detail. But this is absolutely necessary right now, not only for Ukraine, not only for Europe, but for the whole international law based order.
Mykola, that's an impressive concluding thought. It's a clarion call to action that is being taken and needs to continue to be taken to repurpose and utilize these assets, and to remind that this is our conflict as well. And pushing back on Russia and aggression is, quite frankly, in everybody's interest around the globe. So I wanted to thank you for taking your valuable time to share your thoughts and ideas, to educate me and to educate our listeners. It's been a real honor and a privilege to know you for many years now, initially with your time at Truth Hounds and our collaboration on investigating and creating mechanisms to investigate Russia's atrocity crimes, and our continuing engagement over the years. So thank you very much for your time and your energy and your clarity on this very complicated topic, but also for all the amazing work that you're doing to help Ukraine utilize the legal infrastructure that you, I, and our colleagues really care about and believe in. So thank you, Mykola.
Thank you, Paul. It's always a pleasure and a great word of gratitude to the whole team of Public International Law and Policy Group, both for this series of podcasts and for the expertise you provide to countries like Ukraine in time of dire need. Thank you very much.
Thank you, Mykola.